not easy hauling from the other room here in that time. Mr. Chairman, members of the committee, my name is Michael Kramer. I'm a volunteer, and I volunteered for the Rhode Island Coalition Against Gun Violence, not the Coalition Against Dropping Things. And my comments will be brief, a promise that appears to be hard to keep in this room, but I'll try to keep it. And that's because none of these are really new issues. They've all been discussed extensively already and in past years. But I plan to address 6039, 640, and 5729, which are bills which seek to radically lower the bar for the issuance of concealed carry permits in Rhode Island, and also to open Rhode Island to non-residents who visit who have permits in their own states to carry. I think those are bad ideas. I'm also going to comment briefly on 5155, an effort to limit high-capacity magazines to no more than 10 rounds. I volunteered to do this for the coalition because I, like many people, believe that we need to address gun violence in this country. It's not satisfying to me to say, well, we haven't had that problem in Rhode Island, so let's not deal with it. In some circumstances, yes, if there's a problem, let's solve it. There is a problem. It's a nationwide problem. We shouldn't have to wait in Rhode Island until there is a shooting in school or some other horrific event before we do something about it. As members of the General Assembly, you would feel awful if your inaction prevented something from happening. A good place to start is to deal with a misunderstanding that many people have, and this is with regard to the right to carry a concealed weapon. Actually, to carry a concealed weapon or carry openly. And that is that this is somehow a Second Amendment issue. There is no constitutional right to carry a concealed weapon in this country or openly. That's what the law is. The United States Supreme Court in Heller said there's a constitutional right subject to certain limitations, reasonable limitations. There's a constitutional right to maintain and bear arms in your home and to maintain and bear arms in your place of business if you're the owner of that place of business. But Heller does not authorize concealed carry or open carry. The Rhode Island Supreme Court in 2004 in the Mosby case ruled on this, and the Rhode Island court made it clear, our Supreme Court made it clear that this is not a constitutional issue. If the statute says you're entitled to carry a concealed weapon and you qualify under the statute, then you should get your permit. But this is not a constitutional right, and that's something that we all need to be reminded about. Now, the pro-gun advocates are lobbying for three bills, 6039, 640, 5729, among others. Essentially, this would require the issuance of a CCP to pretty much any adult in Rhode Island, unless there's a specific reason, the person's a felon or something like that. But right now, these provisions to change the law on qualifying for a CCP will make it almost impossible to deny a permit by the Attorney General or by the police chiefs. And the devil is in the details in the proposal, which I urge you to read. The current law, this is 114711, requires that a CCP applicant be a suitable person and have a good reason or a proper reason to obtain a permit. So you have to be a suitable person, and you have to have a good reason or a proper reason. 6039 changes the law so that instead of having a good reason or proper reason, it would be any lawful reason. So a good reason or proper reason might be I carry cash, I need a weapon. But any lawful reason means any reason that is not unlawful. So that if I say I want a CCP permit under this, CCW permit under this new law, if this were the law, and the reason why I want to do it is I like guns. I feel good having a gun. I feel better having a gun. That would be a lawful reason, and that would qualify you under prong number one. So now we open the door for any reason as long as it's not an unlawful reason. On the issue of suitable person, which is where the Attorney General comes in and where the police chiefs come in, putting the burden on the licensing authority, and this is a proposal, to have clear and convincing evidence that the reason is a clear and present danger to himself and others, is an absurd legal standard. Clear and convincing reason and clear and present danger, to those of you who have been to law school or have learned your law through your jobs, these are magic words. They have great meaning. And for the Attorney General to be able to establish by clear and convincing evidence that there's a clear and present danger such that someone is not a suitable person, writes out, redacts the words suitable person from the statute. These changes would make it pretty much impossible for any licensing authority to deny a weapon other than to a felon. Read the proposed language and think of it in that sense as to what it really requires, and it's pretty scary. This past January, Esteban Santiago, a man with a history of mental health problems, killed 5 people at the Fort Lauderdale airport. You all read about that. This was just a few months ago. Mr. Santiago had a permit to carry a concealed weapon in Florida. Under current Rhode Island law, a police chief or the Attorney General could deny such an individual a CCP. Under this new proposed law, a Santiago in Rhode Island would get a gun permit. Public records indicate some 729 shootings by CCP holders in the 40 states in the last few years, resulting in 928 deaths, 17 police officers killed. Rhode Island's gun violence record is better because we have good laws in place. We need better laws, but lowering the bar so that everybody gets to carry a weapon and arming the population is going to end up in more violence and more injuries and more death. I'm also objecting to the provisions about granting the right to carry to anybody who's got a CCP in another jurisdiction. And by the way this statute is written, you should read it carefully, it is not limited to situations where the other state has rules comparable to Rhode Island to get a permit. Actually, 5729 mandates reciprocity to any state which grants Rhode Island reciprocity, period. It doesn't require the Attorney General to reach an agreement. Now, the Attorney General can reach an agreement, but 5729, looking at it as a lawyer, stands by itself, and it mandates the recognition of a CCP license or permit to anybody who comes in automatically. Newport gets pretty rowdy on a Saturday night. There's a lot of alcohol consumed. It's not a bad thing. It brings in tourist dollars. But do you really want a CCP holder visiting from out of state to be packing heat on a Saturday night in Newport? I don't, and I doubt that the majority of your constituents would want to see that either. Now let me turn briefly, we always say briefly if you're up here, to 5155, which seeks to ban high-capacity magazines. This is an effort to limit the carnage in the event of a mass shooting. Would it prevent a mass shooting? No, but it could limit the damage. You may recall that the shooter at Sandy Hook Elementary School killed some 20 children in less than 5 minutes. He had a high-capacity magazine. When he tried to change and remove that magazine and put it in a new magazine, the gun jammed, and some boys and girls escaped. And ultimately, that's when some of the kids escaped. The same thing happened, by the way, in Arizona, where Representative Gifford and was shot and others were killed, where the shooter had a high-capacity magazine, but had trouble getting the new magazine in. I know in TV and the movies, the hero quickly and effortlessly takes out one magazine and puts in the other on the run. The reality is quite different. The only one I'm familiar with is the M16, because I qualified on it multiple times in the military, as I'm sure many people here have. And that's the military version of the AR-15. It's not that quick and not that effortless to change magazines, especially, I would imagine, in the middle of an assault with all the pressure that's going on. 62 mass shootings over the period 1982 to 2012 involved high-capacity magazines. Half of the shootings involved high-capacity magazines. Common sense says if we can slow down the shooter in changing magazines, he's only got 10 or she in the gun, and therefore has to change it, that's going to mean less people will be killed before somebody intervenes. Connecticut, Massachusetts, and New York, as you've heard, all ban magazines with more than 10 rounds, and Rhode Island should as well. Now, you may recall testimony last year, and it may be duplicated this year, replicated, by a representative from a Rhode Island-based manufacturer. I remember that testimony, telling us, manufacturer of magazines, saying that they're raising the specter of mass layoffs in the event that this bill is introduced. And I think a prior speaker made reference to that as well. The idea of favoring jobs over the lives of children and men and women is an odd trade-off, but I'm not going to comment on that. But I didn't think his testimony made sense. I couldn't question him because I'm not sitting on your committee. But I did go online and look up at A.T. Wall's Metal Form division, which manufactures magazines. But it doesn't simply sell, its sole business is not high-capacity magazines being sold to gun owners in Rhode Island. Actually, according to the website, they sell to the military, they sell to police, who are certainly entitled to buy magazines of more than 10. And I would guess the bulk of their sales are to people who buy lots of them, which would be the military and and police and law enforcement. I really don't know. What I do know is that the company sells, according to its website, 118 different magazines for insertion into guns. Of those 118 magazines, exactly four, are designed to take more than 10 rounds. 114 out of 118 are 10 rounds or less. And all the ones with the four of them that have more than 10 rounds are for the AR-15. So this specter of mass layoffs, even if that were a fair trade-off, is a false issue. And I think there are a lot of hard questions that would need to be asked of a representative of that company should one appear before your committee. As mentioned earlier, your constituents, your voters, want to see 5155 pass. The 2016 poll conducted by the Princeton Research Associates identified 75% support for limiting magazine capacity to 10 rounds or more. Now, I realize the gun lobby and those who favor weapons will oppose such restrictions, and that's because they see a slippery slope, where the first thing you'll do is to limit the size of high-capacity magazines, and the second thing you'll do is to take away their guns. You're not going to do that. The General Assembly's not going to do that. The Constitution doesn't permit that. So that slippery slope argument is an article of faith with that group, but I don't think it's got validity. I urge you to reject the efforts to lower the bar to get a concealed weapons permit in Rhode Island, and I urge you to send 5155 to the full House for a vote. Thank you.
Thank you. Any questions for Michael?